Ladies and gentlemen of the jury, before proceeding with the court's charge, I want to join with counsel for the government and the defendant in expressing our most appreciative thanks to you for the services you have rendered here and the service that you have yet to perform in this case. I have observed that you have been most attentive to everything that the lawyers, witnesses, and the court had to say, and I have observed also that you have been very punctual in attending, and I know that you will complete your service here in the best tradition of our federal courts. As you have been told, it now becomes the responsibility and the obligation of the court to charge and instruct you in respect to the law which you will apply to the facts as you find the facts to be from the evidence which has been introduced in this case. Evidence both spoken from the witness stand and the documentary exhibits which have been submitted into evidence. The court proposes also to deliver instructions for your guidance in your consideration of the evidence and in your deliberations upon this case. The instructions which the court will give you insofar as they pertain to the principles of law applicable to the case, and this I said to you before you came on to the jury, must be accepted by you as a binding control and guide in your consideration of the evidence and in your deliberations. You will recall when you were examined and later accepted as jurors that the lawyers for both the government and the defendant agreed that you might serve as jurors on the basis of the answers which you made when you were questioned as to your qualifications. The answers you then made to those questions in regard to your competency, qualifications, and your fairness are as binding upon you now as they were then and should so remain until you are finally discharged from further responsibility and consideration of this case. It would be improper and unlawful for any of you to disregard the answers that rendered you competent to serve as jurors in this case. Now again I tell you that the responsibility rests upon you to determine the facts in this case. It is your exclusive function under the law, as the court may give it to you, uninfluenced by any expression of opinion that the court has made or may hereafter make on any matters of fact. Now, as we all know, this is a so-called criminal case. The law in such cases is that the defendant comes into court presumed to be innocent, and that such presumption protects the defendant until such time, until such time shall come when you believe from the evidence in the case beyond a reasonable doubt that the defendant is guilty as charged in the indictment. You should consider the presumption of innocence with all the other evidence in the case, and weigh it carefully, and if from such consideration of the evidence you have a reasonable doubt as to the guilt of the defendant, then you should find him not guilty. The indictment in this case will be sent to the jury room with you. You will have an opportunity to examine it and to read it carefully if it consists of one count charging in substance that the defendant unlawfully, willfully, and knowingly gave $4,000 to Roy M. Tillman, an officer and employee of the United States, as the defendant well knew, with intent to influence Tillman's decision and action on the matter of the audit made by Tillman of the personal income tax returns of the defendant for the years 1956 and 1957. If you find beyond a reasonable doubt that the defendant, Mark Fisher, gave $4,000 to Roy M. Tillman, and that Roy M. Tillman was an officer or employee of the United States, before you can find the defendant guilty of the charge in the indictment, you must find beyond a reasonable doubt that the defendant did this act with intent to influence the decisions and actions of Roy M. Tillman.